Start. Can a claim be maintained before the Motor Accident Claims Tribunal, Tribunal for short, on the basis of a strict liability propounded in Reliance versus Fletcher 1861 to 1873? All England reports so. The tribunal dismissed a claim made before it solely on the ground that there was neither rashness nor negligence in driving the vehicle, and hence the driver has no liability, and the corollary of which is that the owner has no vicarious liability to pay compensation to the dependents of the victim of a motor accident. A division bench of the High Court of Allahabad dismissed the appeal filed by the claimants by a cryptic order stating that there is no error in the tribunal's order. Hence, this appeal by special leave. The accident which gave rise to the claim occurred at about 7 p.m. on 28th 3 1986. The vehicle involved in the accident was a jeep. It capsized while it was in motion. The cause of the capsize was attributed to bursting of the front tire of the jeep. In the process of capsizing, the vehicle hit against one Haji Muhammad Hanif, who was walking on the road at that ill-fated moment, and consequently that pedestrian was crushed and subsequently succumbed to the injuries sustained in that accident. Appellants are the widow and children of Haji Muhammad Hanif, the victim of the accident. They filed a claim petition before the tribunal in 1986 itself, claiming a sum of rupees 2,36,000 as total compensation. They said that deceased Haji Muhammad Hanif was aged 35 when he died, and that he was earning a monthly income of rupees 1500 during those days by doing some business in manufacturing steel trunks. The owner of the jeep disclaimed the liability by denying even the fact of the accident in which his jeep was involved. Alternatively, he contended that any liability found against him in respect of the said jeep, the same should be realized from the insurance company, as the vehicle was covered by valid insurance policy. The tribunal repelled the above contentions of the jeep owner. However, the tribunal found as follows. It appears that the front wheel of the jeep suddenly got burst, resulting in the disbalance and occurrence of this accident, as it is mentioned in Exhibit 2, the report of the police station. Whatever is the circumstances, the rush and negligence of the alleged jeep is not established. Consequently, the tribunal dismissed the claim for compensation. However, the tribunal directed the insurance company to pay rupees 50,000 to the claimants by way of no fault liability envisaged in section 140 of the Motor Vehicles Act 1988, for short the MV Act, corresponding to section 92A of the Motor Vehicles Act 1939, the old MV Act. Aggrieved by the said rejection of the claim, the appellants moved the High Court of Allahabad in appeal as per the provisions of the MV Act. On 28 4 1999, A division bench of the High Court dismissed the appeal for which a very short order has been passed. It reads thus: Heard learned counsel for the appellant. Finding has been recorded that the tempo overturned and there were no negligence or rashness of the driver. Hence, rupees 50,000 has been awarded as compensation, which is the minimum amount. There is no error in the order dismissed. Stop.